There's a lot of questions left unanswered after a ballot question to legalize recreational use marijuana overwhelmingly passed in New Jersey. But one thing is for sure, employees cannot be fired or not hired for blazing up on their own time.
And under Bill 21, it states that employers cannot refuse to hire, cannot take any adverse action, and they can't terminate an employee for use or not use of cannabis unless they have a rational basis for doing so that's reasonably related to their employment.
But what is considered to be a rational bias? That's still yet to be determined.
Most likely will be fact sensitive depending on a case-by-case basis.
Unlike alcohol, there is no instantaneous test to determine sobriety, which will ultimately be the challenge for employers.
They're going to look for the symptoms of marijuana use. So whatever they may be, they'll train their managers and their supervisors regarding looking at objective symptoms of marijuana use to see if their employee is impaired. If they can tie that to a rational basis that it's related to their employment, most likely the employer will have a right to terminate the employee.
The new law does not require employers to change their drug and alcohol policies, but Masmano says companies should make sure their policies are up to date.
Really, I think it's going to come down to employers kind of treating this very similar to alcohol. You can have alcohol outside of work, and many people do. However, you can't come to work impaired.
As for jobs that randomly drug test, there's no mention if employees in certain fields of work, like law enforcement, would be forbidden of recreational use altogether, which could ultimately lead to future legal issues for certain companies. Heather Fordham, New Jersey News Network.